Good afternoon, everyone, and thank you, Taylor. I am Shoikhetbrod. I am one of the managing partners of Tully Rinckey PLLC, but I've been practicing federal sector employment law throughout my tenure at the firm for about 10 years now. I've handled all types of cases, Merit Systems Protection Board, which is the topic today. I've litigated many appeals at that agency, EEOC cases, and other agency cases specific to those agencies, like the Veterans Affairs and other similar agencies like that. So for today, we are focused on the MSPB, the Merit Systems Protection Board. And so there's a couple things that I want to go over with regard to the MSPB. Number one, what is the MSPB? What does the MSPB have jurisdiction over to hear, and what does it not have jurisdiction over to hear? What happens after you receive an MSPB decision, and how do you pursue that claim? Understanding the different stages of an MSPB appeal once a filing is made, and whether you can recover any damages in an MSPB proceeding, and if so, under which circumstances. We can go to the next slide, Taylor. So the MSPB is a federal executive agency. It's an independent quasi-judicial agency that was first established through the Civil Service Reform Act of 1978. That law became effective in 1979, so the MSPB officially started in 1979. Its purpose is really to protect federal merit systems principles by ensuring that federal employees are protected from abuse of those principles by agencies and agency management, providing guidance to agency supervisors on creating a diverse federal workforce that is fair and effective. The board, and sometimes we call the MSPB the board itself, has two types of jurisdiction. One is original jurisdiction, and the other is appellate jurisdiction. Original jurisdiction are cases that are filed directly with the board. Sometimes they're filed by the Office of Special Counsel, which is another federal executive agency that has jurisdiction over about 14 prohibited personnel practices, including whistleblower disclosures and whistleblower retaliation. When someone files with the Office of Special Counsel under those prohibited personnel practices defined by statute, Special Counsel has the option to file directly with the MSPB under its original jurisdiction regulation. Other types of original jurisdiction include individuals that have been removed from the senior executive service for performance deficiencies and for informal hearings. And then another aspect of original jurisdiction are those actions that were taken against administrative law judges. So administrative law judges, for example, those from the Social Security Administration, if they are being proposed for termination or some sort of adverse action, they would not be filing an appeal. Instead, their agency would file a complaint directly with the MSPB, and the case would be litigated. Typically, it's not an MSPB judge that oversees those cases, but it is a judge from another agency under the board's jurisdiction. We can go to the next slide, Taylor. So as to appellate jurisdiction, and this is probably the topic that touches upon the attendees here, there's a lot of different types of actions that the MSPB has appellate jurisdiction over. The most common are adverse actions. And what is an adverse action, at least for boards? Appellate jurisdiction are removals, so termination of employment of tenured employee, those who are past their probationary period. If they are removed and they're tenured, they're entitled to due process rights, meaning that they are entitled to notice and opportunity to respond from the agency level. And then if that decision is effective, they have the right to appeal that to the Merit Systems Protection Board. Also, other adverse actions such as reductions in pay or grade, sometimes known as a demotion. Same thing, if they're a tenured employee, they get notice and opportunity to respond at the agency level, and then they can appeal that decision to the MSPB. Suspensions for more than 14 days Another adverse action that is appealable to the MSPB. These do include constructive suspensions. So if someone is, for example, placed on enforced leave, but they are ready, willing, and able to return to work, that can be considered a constructive suspension that the board has jurisdiction over. Also, furloughs for 30 days or less is something that the board has jurisdiction, and involuntary resignation or retirements. Those can be considered constructive removals that the board may have jurisdiction over. So those are the typical adverse actions that we see at the MSPB. Other appellate jurisdiction issues that can go to the MSPB are retirement appeals. So if you're in the federal employee retirement system since 1990, when that system became in place, and there's an issue with your retirement application or disability retirement application or an annuity determination, you would have to first go to the Office of Personnel Management, exhaust your options there, let OPM issue their decisions, and if you want to pursue it any further, that would go to the MSPB. So it's not just FERS, but also the civil service retirement system that is applicable. For probationary employees, they have very limited rights to MSPB appeals. Those limitations include if the termination was motivated by partisan political issues or marital status, or if the termination was based on a pre-appointment reason, such as there was an action that happened prior to your current employment that caused the termination of your probationary employment. That may be something the board may consider as part of its jurisdiction. But in that situation, typically they don't apply to accepted service employees and would generally apply just to competitive service. There's also restoration appeals, so individuals that are recovered from a work-related injury, usually someone who was on workers' compensation, OWCP, and they have recovered. They may have restoration rights to their employment, and so when agencies fail to provide that, that may be something that the board has jurisdiction over. And then we have performance-based actions under Chapter 43, which can be a removal for performance-based reasons. That typically happens when someone is on a performance improvement plan and they're given an opportunity to improve for a 90-day period. And if they do not, and then an action is taking place, then they can appeal that action to the MSPB. And that also includes the motions under Chapter 43 as well. We could go to the next slide. There's some ancillary issues that fall under MSPB jurisdiction, not as common, such as RIFs, reduction in force, where separation or demotion or furlough for more than 30 days. That's a little more rare, but it did happen quite often in the past. There's employment practices appeals, denial within grade increases. So, as federal sector employees, most employees fall under the general schedule, GS9, GS10, whatever it may be, but there are also steps. So you could be a GS 10 step 1, and then 52 weeks within the step 1 time and grade, you're waiting for your step 2. And if you don't receive your step 2, that may be something that the board has jurisdiction over. But first, you would have to exhaust that with your agency, receive a decision, and then appeal that to the MSPB. There's also suitability actions. Typically, those relate to an individual's character or conduct that may impact the efficiency or integrity of service. They include cancellation of eligibility, a removal, a cancellation of reinstatement eligibility, or a debarment. So sometimes this falls under or is very similar to pre-appointment reasons for termination. But suitability actions are very complicated, and sometimes they are done by the Office of Personnel Management or under delegated authority to the agencies. Something like a non-selection is not typically a suitability action, but it may be for veterans' preference rights, for example. which the board also has jurisdiction over. And then there's various actions involving those within a senior executive service, SES employees, removals and suspensions, basically all the same adverse actions that we discussed on that first slide. You can go to the next slide, Taylor. And then we have all these other ancillary issues that are extremely rare to see at the board level. And so, those are reinstatement appeals for individuals that fall under the Foreign Assistance Act of 1961 or the Indian Self-Determination Act or the Taiwan Relations Act. These are very rare, but still falls under the board's jurisdiction. And then we have appeals under USERRA, the Uniformed Services Employment and Reemployment Rights Act. Those military members or veterans that believe that an action was taken against them motivated by their military service or veteran status can appeal directly to the Merit Systems Protection Board. And those also that claim veterans' preference rights have been violated can appeal to the MSPB as well. And then finally, on the last slide here, there are appeals within the board's jurisdiction with regard to whistleblower retaliation. And I touched upon this a little bit earlier, but those types of appeals need to be exhausted first with the Office of Special Counsel. Again, Special Counsel is a separate executive agency that has jurisdiction over 14 prohibited personnel practices, one of which is the whistleblower statute. So you would have to file with the Office of Special Counsel first, allow them to investigate or give them enough time to investigate. If Special Counsel closes the case, they will give you a notice to allow you to file something called an individual right of action, which is filing with the Merit Systems Protection Board. Go to the next slide. Thank you. And then there are limitations on jurisdiction. So we just went over what the board does here, but the board's jurisdiction is not plenary. There are limitations. Those who fall under collective bargaining agreements under Section 7121, the bargaining agreement may be the exclusive way to file with regard to an adverse action. But if it is an adverse action that is a demotion, a removal, or a suspension, and you fall under the negotiated grievance procedures, you essentially have an election of remedy at that point. You can go through the grievance process with your union under the bargaining agreement, or you can go to the MSPB, or if you're seeking corrective action at the Office of Special Counsel, you also have that option. That said, you cannot choose all three. It is an election. So if you file under the grievance procedure, you've elected your remedy to go through the grievance procedure. If you file with the MSPB, you've elected your remedy at the MSPB and can't then go back to file your grievance through the union's procedure. The election needs to be knowing and voluntary. So if you were not aware that, for example, the union filed a grievance and then you filed an MSPB appeal, you would have to establish that your election was not knowing and voluntary. Other than that circumstance, this is an election of remedy, so you can't file all three. You can only choose one. There are some limited exceptions to that, and indicated here at 3. One exception is actions involving discrimination under Section 2302B1 or other prohibited personnel practices. That appealable action that is excluded through the grievance procedure may be raised only under the board's appellate procedures. So if the negotiated grievance procedure or the bargaining agreement does not specify one way or the other, that may be something that falls under the board's jurisdiction. And we can go to the next slide, Taylor. And so choice of procedure, and again, this goes back to electing your remedy. And again, you can only choose one. You cannot do two. You cannot do all three. If you are removed from your employment, for example, you can file with the MSPB, but you can't also file a grievance. You can file with OSC, but you can't also then file a grievance. So you can only choose one of that. And again, it needs to be knowing and voluntary. You can go to the next slide, Taylor. So when does an appeal need to be filed? So generally, most appeals need to be filed within 30 calendar days of the effective date of the decision that you receive at the agency level. Every decision typically says when that is effective. So if, for example, you're removed from federal service, the decision will say at the agency level that is effective on whatever day it is. It does not necessarily mean it's effective on the day that you receive the decision. Some agencies will wait till the end of the pay period to make a decision effective. And so your deadline to appeal would be calculated from that date and not necessarily from the date of decision. But generally, it is 30 calendar days. There are exceptions, like anything else in the law, there's exceptions. For an individual right of action appeal, those that we discussed involving whistleblower complaints that are filed with the Office of Special Counsel, the regulatory deadline is 65 calendar days from special counsel's notice that they closed the case. However, the statutory deadline is 60 calendar days. Now, why is there a disparity and a distinction here? I wish I could tell you, but I follow the statutory deadline because statute essentially supersedes regulation. And while the regulation here is a little more favorable to employees by giving you an additional 5 calendar days to file, I always err on the side of caution and I calculate my deadlines early. So I would strongly recommend that if you do have an OSC complaint that can lead to an individual right of action, you would calculate 60 calendar days from that notice. And then we talked a little briefly about, what type of cases fall under an IRA appeal when you file with special counsel. And these are all the types of personnel actions that fall under retaliation for being a whistleblower. So if you made a protected disclosure, and essentially that you made a reason, or you had a reasonable belief of a violation of rule, law, regulation, you disclosed that, and then you claim retaliation because there was an adverse action or adverse personnel action, these are the types of personnel actions that the board will consider. So an appointment, a promotion or a lack of promotion, a removal, suspension. Most recently, the board has also accepted performance evaluations as a personnel action, a reassignment or a detail, failure to reinstate or restore, those types of actions, bonuses or not getting bonuses, anything that really impacts the terms and conditions of your employment would be considered a personnel action that can be raised in a whistleblower retaliation IRA. And then for USERRA appeals, one of the benefits that's unusual compared to other statutes is there's no time limit. So there's no 30-day period, there's no 60-day or 65-day period. You can theoretically file a USERRA appeal at any time to the MSPB. Again, there's always a caveat with that. There is a legal doctrine called latches. And latches is essentially that you've waited too long to file an action. And typically the board and other courts will say 6 years or more is too long. And the reason behind that generally is that the individuals you may be complaining about that took the action, discriminatory action against you on the basis of military service or veteran status, those individuals may not be there anymore. Or the information that you're alleging may not be available anymore because too much time has elapsed. Notwithstanding, again, USERRA has no statute of limitations, and so theoretically you could file that appeal at any time directly to the MSPB. And then you have the Veterans Employment Opportunities Act, VEOA appeals. Those need to be exhausted first with the Department of Labor through the Secretary of Labor, and you have to give that agency 60 days to try to resolve. And then after that 60-day period, you can file an appeal with the MSPB, or if you receive a notice from the secretary that they're unable to resolve your matter, you have a very short time frame to file an appeal with the board, and that's only 15 days. So in individual right of action appeals, those whistleblower cases, VEOA appeals, you need to show you've administratively exhausted. We have USERRA in here as well, but USERRA does not require you to exhaust. That said, if and you do have the option to file instead with the Department of Labor alleging a USERRA violation, or the Office of Special Counsel alleging a USERRA violation, and then if you file with the MSPB, you're going to have to show that you've exhausted those options. But you don't have to file your USERRA appeal with DOL, and you don't have to file it with OSC. You can file directly with the MSPB. And then we have 38 USC 714. And those are appeals specific to Veterans Affairs employees, covered individuals. Covered individuals are those that are excluded from the statutes that are listed here. Those individuals that are excluded are like doctors and nurses, individuals typically that do not fall under the GS scale at the Veterans Affairs. Those that are covered can be medical support assistants or health technicians, VA police officers. Those types of individuals are covered individuals for the most part. And if there's an adverse action implemented under Section 714, they have appeal rights to the MSPB. However, the deadline is also very short. It's 10 business days, not calendar days. So that's also very unique. But it's 10 business days, and it's subject to an expedited review at the MSPB. That means that the MSPB has only 180 calendar days from the appeal to issue a decision. That sounds like it's a long time, 6 months to adjudicate an appeal. It's not, and honestly, judges rush through these cases sometimes, and no extensions are usually provided. It's difficult to engage in settlement discussions, and so, unfortunately, it does move very fast, depending on your circumstances, or that could be fortunate, again, depending on your circumstances. And then we have the process of filing an MSPB appeal. Traditionally, appeals were filed by mail or fax, but in the last several years, everything's been filed electronically. The MSPB has an e-appeal system. It's an electronic docket system. It's a new system that they recently transitioned at the end of October, I believe. So it's all on their website, e-appeal.mspb.gov. And you would essentially fill out this form. It's an MSPB Form 185. Has some basic information here as to the employee's name, their address, telephone numbers, email, etc. But also the agency that took the action against you. And then you would have to indicate the type of employment that you had. Were you a permanent employee, an applicant, temporary, retired, seasonal, etc. And then the type of appointment, competitive, accepted, post-service, SES, or other. You would indicate what your series was, your occupational series of cluster, your position title, your grade or pay band, and duty station. You'd also specify how long you've been in federal service, total federal service, and whether you were in a probationary or trial period at the time the action was taken against you. Number 11 is very important, and it's in bold and says hearing and whether you want a hearing. So one of the very unique things about the MSPB, and we'll get to it in a bit, is that if you establish that the action that you're appealing is under the board's jurisdiction, and if you establish that you have the right to file that appeal, so you're essentially non-probationary, you're a tenured employee, and if you request a hearing, you will have a hearing. So MSPB is very unusual with that, because in other tribunals like the EEOC or even in federal and state courts, there's ways to dismiss a case, whether it's through a motion to dismiss or a motion for summary judgment, to avoid going to a hearing or to a trial. But at the MSPB, that does not necessarily happen. Actually, there's no regulatory or statutory way for that to happen. If you meet all the elements of jurisdiction and you want a hearing, you will get a hearing. On the second part of the form, you would explain what the action was that was taken against you. There's removal here, reduction in pay, suspensions, failure to reinstate. So you would just check which box applies to you. And then on 13 and 14, when you receive the agency's decision and the effective date of that decision. And then on 15, whether prior to filing the appeal, you agree with the agency to engage in alternative dispute resolution. The reason why that's here is that if you and the agency do agree to ADR prior to filing the appeal, there is a tolling period for your deadline to file that appeal. If you were to do that and agree to ADR before filing the appeal, I would ensure or want you to ensure that you get that in writing from the agency that there will be a tolling on the appeal deadline and they won't contest to any argument on untimeliness. I would also not risk that, and I would file your appeal nonetheless. On 16, here's a little box for you to explain what your appeal concerns. There's not a lot of room here to go into details, and sometimes the details are very important in filing these appeals. So typically what I would recommend here is to have a continuation page or several continuation pages, not too many, but really going over the facts of why you're appealing, the violations that led to your appeal, and in this box I would say see continuation sheet. But if you're able to include everything that you can into this small box here, then you should probably do that because it really is just a formality to ensure everything is there. And then on the second page here, there's a little more information, whether you filed a grievance under the negotiated grievance procedure. Again, we talked about this previously. There is an election or remedy issue. So if you check this box as yes, you may have an issue with regard to your election or remedy and whether or not you can file an MSPB appeal. And then number 18 is only with regard to those IRA appeals or the whistleblower cases. And so when that Office Special Counsel complaint was filed and when the Office Special Counsel issued their termination of investigation. And then 19 is only with regard to usury cases or veterans preference cases. Again, same thing. If you file with the Department of Labor, you would specify when, did they make a decision, and if so, when was that decision issued. And on part 3, this is only for retirement cases or OPM cases. You would indicate what retirement system you were enrolled in, CSRS offset, or FERS, whether you're a current employee, an annuitant, or a surviving spouse, all of which have rights under the retirement system to appeal. The date of retirement, if you know, and then explaining the decision that you are appealing. And then when you receive that decision from the agency or from OPM, and explaining briefly why you are appealing again. And then on the following page, there's the designation of representative. So if you do want to designate a representative, whether it's an attorney or a non-attorney, someone to represent you at the appeal, you would indicate here. You'd specify who they are, where they're located, and all the information that's pertinent on this form, and you would sign it and then date it. And then part 5 is the certification, and this is you certifying that the statements that you made on the form and on the appeal are true, complete, and correct to the best of your knowledge. So that's the form. Typically, it could take a couple hours, depending on the nature of the case, to complete, or it could be much less time to complete that. But the form is required. Your appeal can be rejected if your form is not completed correctly and completely. And if you're going to appeal, an action, you should do it electronically, especially now that everything is through the e-appeal system. And after you file your appeal, the board moves pretty fast. And so typically, in my experience, you will probably receive the assignment of an administrative judge within a couple days. Again, very unusual and unique compared to the EEOC, where you could be waiting several months for a judge at the EEOC to be assigned. But at the board, it may take about a week, sometimes even less than a week. And the first thing you would receive is an acknowledgement order. The acknowledgement order will specify there will be a caption stating, the employee's name as the appellant, the agency that you're appealing against. It will have a docket number to identify specifically your appeal case number, and it will specify who the judge is assigned to your case and out of what office of the MSPB. In the order itself, there will be deadlines associated there. The first deadline typically is to file your designation of representative. If you didn't file that, you'll have 10 days to do that. Or if you made a mistake on your form about requesting a hearing, the order will specify you have, about 10 days to change your request if you do want a hearing. But some of the more important deadlines that are specified here is the agency response and file. Typically, that's a 20 calendar day deadline from the date of that order. The agency response and file is essentially them responding to your appeal and why your appeal should be denied. They also include very required and specific evidence to make their arguments, and it needs to be formatted and submitted in a particular way. Another big deadline typically in these orders is when to initiate discovery and the time period to serve your discovery requests. Typically, that's 30 days from the date of the order, and then the responses to those requests are typically 20 days from there. The judge would also specify if there's an issue with discovery, how to raise those issues, and when to raise those issues with the administrative judge. Those are the typical days that are specified in these orders, but what we've been seeing recently is some judges are lessening those days or lowering those days and making the deadlines even quicker. So make sure if you do file your appeal and you do get acknowledgement order to read it very carefully, to counter those deadlines immediately, because they are important, and if those deadlines are missed, you may negatively impact your case, unfortunately. And then later in the MSPB process, once discovery is completed, the judge will issue something called a hearing order. The hearing order will have various deadlines. On the very first page, it will say when your hearing is scheduled, on what day or what days. Sometimes these hearings could be multiple days. Sometimes they're one day, but it will specify when. It will specify what time, and it will specify what platform. Most MSPB hearings, I would say 99% of them are remote hearings done through Zoom for Government. And so for the most part, you're not going to have to go anywhere in person for your hearing, but the order will specify. What the order will also specify is when your pre-hearing submissions and pre-hearing conference will be. A pre-hearing submission, and the order will specify what the judge is seeking in those submissions, but typically what's in a pre-hearing submission is essentially what are the issues on appeal, what are you appealing, again, restating essentially what your case is, any defenses that you may be raising. So if you're saying that your termination was based on discrimination, for example, or retaliation for your whistleblower matter, you would put that in your pre-hearing submission. So we go through all the issues, but also importantly, you would specify which witnesses you want to testify at hearing, and not just which witnesses, but what's their proffer, what relevant information do they have, and what testimony do you believe they're going to provide at the hearing. And then also the exhibits. So what exhibits, what evidence do you want the judge to have at hearing? all those things would be included into a pre-hearing submission. And then you would have a pre-hearing conference, and the conferences are typically a week after the submissions are filed. And the conferences can be short, depending on the judge. It could be 30 minutes, or they could be long and sometimes last the full day. But a typical pre-hearing conference, the administrative judge will go over the party submissions, will go over what the issues are, just to confirm, this hearing is about a removal, or this hearing is about a suspension, or the employee raised all these defenses. The judge will go over that and confirm that. The judge will then go witness by witness and make rulings as to whether those witnesses will be approved for hearing. So usually they start with the appellant's witnesses, and we'll have it back and forth with the appellant and the agency attorney as to the witness and the relevancy of their testimony, and make rulings for each witness. For exhibits, it really depends on the judge. I've had judges that do go through the exhibits one by one. I've had other judges say that the parties need to move exhibits into evidence at a hearing. It really depends. And then one of the other things that judges love to discuss during these conferences is settlement, and whether the parties engage in settlement discussions or want to engage in mediation. Assuming that all happens and there is no settlement, again, if you requested a hearing, you have a right to a hearing. And so that's the last step of this MSPB appeal process. So if you are alleging an appeal based on adverse action, like a removal, it is the agency's burden of proof to establish that the removal was proper, and their burden is under a preponderance of the evidence. So what that means, and it's defined by regulation, is the degree of relevant evidence that a reasonable person, considering the record as a whole, would accept as sufficient to find that a contested fact is more likely to be true than untrue. So in other words, that it's 51% or more likely that you committed the misconduct. And that is the agency's burden. They have to establish that for those types of appeals. On the Chapter 43 performance-based action, again, those appeals where you may have been subject to a performance improvement plan and given an opportunity to perform, and then if the agency took an action against you under Chapter 43, those appeals are reviewed under a substantial evidence standard. Substantial evidence sounds like a lot of evidence, but it really isn't. It's actually a lower burden than preponderance of the evidence. Substantial evidence is the degree of relevant evidence that a reasonable person, considering the record as a whole, might accept as adequate to support a conclusion, even though other reasonable persons might disagree. Sometimes the standard is a mere scintilla of evidence. In other words, any evidence may be substantial evidence. So again, very low standard, and that is the standard under Chapter 43 appeals. If you raise an affirmative defense of whistleblower retaliation, or if you file an individual right of action instead on the whistleblower retaliation, it's your burden of proof to establish by preponderance of the evidence. And then we talked about 38 U.S.C. Section 714 appeals, those appeals particular to Veterans Affairs employees. They are reviewed under a substantial evidence standard at the MSPB, but at the agency level, during the due process stage where they give you a proposed action and you respond to it, at the agency level, it's a preponderant level. It's a preponderance of the evidence standard. At the board on review, the board will look at it from a substantial evidence standard. And during the hearing process, the administrative judge will explain the procedures again. We'll go through everything that's before the judge. Again, what the issues are, discuss stipulations, narrowing the issues, the possibility of settlement, rule on witnesses, rule on exhibits. And then at the hearing itself is like a trial. You have the right to examine and cross-examine witnesses. You usually have the right to make an opening and closing statement, and then ultimately you have the right to a written decision by the administrative judge. So on the next slide, when the hearing is done, it doesn't typically happen on the same day. It could happen several weeks later. It could happen months later. But per regulation, the administrative judge is required to issue a written decision, either in your favor or not. If it is in your favor, great. If it's not in your favor, that's unfortunate. But both parties have the right to appeal the administrative judge's decision. The initial decision will specify toward the end when the decision becomes final. It's usually 35 calendar days from that decision. If no appeal is filed within that 35 calendar day window, then the decision is final. If an appeal is filed on the 34th day, for example, then the decision is not final and it goes up to the next level at the board. The board has two levels. At the initial appeal level, you have an administrative judge, and at the second level, you have the board itself, a three-member panel that makes the decision on a petition for review or the second level appeal. Also, alternatively, you have the right to bypass the board after the initial decision and file with the Court of Appeals for the Federal Circuit. And if you don't bypass the board, you still have the right to go to that second level review, get a decision by the board, and then to the Court of Appeals for the Federal Circuit. So as to damages, which is the next slide, typically damages do not come up unless you have an affirmative defense. So for example, if you file an appeal of your termination and you do not raise an affirmative defense, you do not get compensatory damages for that. The relief for a removal appeal, if you were to win that appeal, is to get your job back and to get your back pay and any benefits and leave and attendant benefits that you're entitled to that you've lost because of your removal. However, if you allege your removal was improper, but you also allege an affirmative defense of, let's say, race discrimination or whistleblower retaliation, and you prevail on that defense, you can get damages. So you can get compensatory damages, which are pecuniary and non-pecuniary damages. They could be out-of-pocket damages, or they could be pain and suffering damages. You can get consequential damages, particular in individual right of action cases, which is unique. And then for veterans preference cases, you can get liquidated damages, which is essentially double the back pay that you may be due. In any other circumstance, damages are not available. In a USERRA case, there is no compensatory damages provided by statute. So again, this only comes up when there's an affirmative defense that you prevail on. Any other typical appeal, you would not be entitled to damages. And then from there, why would you get an attorney? Well, I just provided you with a lot of very complicated information that I was able to procure and experience for the last 10 years of doing this, working with a lot of different judges and a lot of different clients and a lot of different agencies. So one of the benefits of having an attorney is the attorney knows the process. Also, they're very good typically at negotiating with agencies to settle cases in your best interest, but also having an attorney, they would be responsible for any deadlines. One of the easiest ways to get a case dismissed is by missing a deadline. And while there are exceptions, good cause exceptions, those are things that you do not want to happen in the first place. Establishing MSPB jurisdiction, we went over it. There's some very complicated concepts there. So having an attorney to respond to those orders is very important in arguing why jurisdiction exists at the board. And then utilizing mitigating factors related to your case. So we didn't talk about it, but in adverse action appeals, for example, if you are removed or demoted or suspended for 14 days or more, while the agency may prove that you committed the alleged conduct, there's still another analysis there as to whether the penalty is reasonable under the circumstances. So if this was the first time you committed misconduct and you have 20 years of service and the agency went ahead and removed you, well, there's another analysis that needs to be done as to whether that removal is reasonable. and it's called the Douglas factor analysis. So obviously, we can assist with that as well. And really all facets and all stages of the MSPB appeal process. Otherwise, as a pro se, someone who does not have a representative or someone who does not have an experienced representative, this is a lot to do and a lot to take in. And as I explained, the MSPB process can move pretty quickly sometimes, especially if you're a VA employee that filed an appeal under Section 714. The case needs to be decided within 6 months. Now, a lot happens in that 6 months. So another benefit of having an attorney or a representative to assist you. And so that is all the slides we have for today's presentation. We do have a few minutes to go over some questions. And so we did get some pre-submitted questions here that I did flag that I want to go over for those that may have asked those questions. And feel free to submit any questions in the chat box as well. So there's a couple questions here about cases that have been pending for a long time, where the employee has not received the decision, and that they try contacting the board and aren't getting very far with that. So there's a couple things you can do with that. Number one, again, the board is a federal executive agency, so you can always submit a Freedom of Information Act request and get information about your appeal. That's one way to do it. It's not the most expeditious way of doing it. Contacting the board, this person who asked the question already did that, but I wouldn't just call. On the board's website, they also have email addresses for each field office. So I would send an email to the field office. The last option, which is probably the quickest option, is that if you have an e-appeal account, you should be able to see everything on the docket. So you would log in, click on your case, and you would see everything that's there. If a decision has not been issued, then you just need to wait, unfortunately. It's not my practice, nor do I recommend that you reach out to a judge and ask them to hurry up. That usually does not result in a great outcome for you. Let the process unfold, let them make their decision. But the biggest concern I have is if you missed the decision being issued, the reason being that then you may have missed your appeal deadline subsequently. So those are the three options. You can call an email, submit a FOIA request, but really you should have access to the docket and you should be able to see everything that's going on there. One of the questions in the chat is the agency required to provide the appellant with a discovery request, or is it just the appellant making the discovery request? So the parties are not required to engage in discovery at all. The acknowledgement order does specify the deadlines to initiate discovery, but the parties are not required to engage in discovery. The agency is required, however, to file its response and its file, which is essentially why the appeal should be denied, and then documents that they want to use to support why the appeal should be denied. But the parties are not required to engage in discovery. It does happen sometimes where only the appellant serves and the agency does not, or just the agency serves and the appellant does not. So, but again, it's not required. Do or may they sometimes stop using the Douglas factors? So this is a little complicated of a question. For those cases that fall under substantial evidence, specifically under Chapter 43 performance-based actions. So again, those actions that you were placed on a PIP and they removed you for a performance-based reason and they specify that it's under Chapter 43, Douglas factors do not apply to that. So there is no mitigation of the penalty that's possible in those cases. It's just whether or not there's substantial evidence to support the performance-based action. Under a Section 714 appeal, those again, Veterans Affairs employees, again, on appeal, it's a substantial evidence standard, but in the last couple of years, the Federal Circuit has found that the Douglas factor analysis or the penalty analysis falls under substantial evidence as well. In other words, the decision to remove, for example, the decision to demote must be reasonable as well and supported by substantial evidence. But in typical appeals, Chapter 75 appeals for adverse actions, Douglas factors are required. They are required to be analyzed by the deciding official, and the judge is also required to analyze the Douglas factors as well, the relevant Douglas factors, not all of them, but the relevant ones that do apply. There's a question that was pre-submitted as to how does an EEO discrimination complaint that could potentially be related to a proposed removal for unacceptable performance affect the process? Okay, so another complicated question that I'll try to answer in a few minutes. So you have the right to file an EEO complaint based on, let's say, a removal for performance-based reason, right? You can decide to go through the EEO process and say that your removal was discriminatory on the basis that's protected under Title VII or the Rehabilitation Act or under the statutes that are relevant. If you go through the EEO process, you are creating something called a mixed complaint. And mixed complaints are very complicated. There was a United States Supreme Court decision on mixed complaints recently in the last 10 years that shows how complicated this process is. But essentially what would happen is you go through the EEO process, you go through the investigation, and then at the end of the investigation, the agency will automatically issue a final agency decision. And then from that final agency decision, you would appeal to the Merit Systems Protection Board. And then you go through the MSPB process. Let's say, unfortunately, you lose on that appeal process. On the discrimination component, you can file with the EEOC's Office of Federal Operations. And on the personnel action, the adverse employment action, you could file with the board on the second level or to the Federal Circuit Court of Appeals, but you would have to waive the discrimination component. Now, if you file your EEO complaint and you only allege the proposed action, so let's say you got a proposed removal and you file an EEO case, that's completely fine. If you then receive a decision on that removal, you have the option to include that in your EEO case and go through a very complicated process, a mixed complaint process, or not include your EEO complaint and file instead with the MSPB. At that point, you would have two cases going on at the same time through two different processes. And so this is a very complicated question. If you do have a mixed case like that, where an adverse action that's appealable to the MSPB may also be discriminatory or retaliatory, I strongly advise you to talk to an attorney about it because it is a complicated sector of the law. And during the appeal process, is it possible to argue the appeal in court? So, no, depending on what the question really is asking. As a federal sector employee, if you suffer any of the actions that the board has jurisdiction over, that is essentially your exclusive way to pursue the action. Again, there are some limitations and some exceptions. If you have a board appeal, you can't also then file a court action at the same time. There's issues with res judicata, collateral estoppel, claim splitting, but just generally speaking, the MSPB is essentially your exclusive process, with the exceptions that I mentioned under the bargaining agreement, EEO, for example, and OSC. But going to court is very rare and probably would not be permissible under any of the actions that we discussed here. And all the other questions seem to be case specific. There is one last question here that I did want to kind of talk about, which is the mediation process between agency attorneys and appellants. So the MSPB has a mediation appeals program. It's called MAP. It is a very good mediation program. Both parties, the appellant and the agency, need to agree to engage in that mediation program. One of the benefits is that if the parties agree, it stops all the deadlines on the case. Okay, so you're not also negotiating and mediating and also up against all these deadlines, with a hearing or pre-hearing coming up. So that's a benefit, usually, so you're not overexpending yourself. But the biggest benefit is that at the MSPB, the mediations are handled by administrative judges. Not the judge on your case, but another judge. It could be a judge from a different regional office of the MSPB, or it could be in the same office. But those judges are very experienced in mediations and in negotiations. They are very helpful. They will tell you whether you have a good case or not a good case. They would tell you whether your request for settlement is unreasonable or not. But the goal is to resolve. And most cases end up resolving, most cases end up settling. And the MSPB and their program on mediation is very good. So if you do have a pending appeal, you may want to consider the mediation appeals program at the MSPB. And other than that, everyone else has case-specific questions. So for that, I encourage you to contact us on this slide at the law firm for a consultation, where we can go over your case-specific matter and give you options and give you some guidance as to what to do with that. And other than that, I thank you all for attending today. I hope this was helpful. And I believe, as Taylor indicated, the video will be available and circulated.